right, welcome to the afternoon session of Magistrates. Let's get started, if we can, with Christina Mateer.
Judge, recall?
Okay, sure. Okay, next one I have is Robert O'Brien.
Mr. O'Brien is here, present, Judge, at Maine. Come on up, Mr. O'Brien.
Do you have his DL? No? Okay. All right, good afternoon, sir. You're here on a capias from a traffic offense at a satellite court. It's a driving while licensed suspended offense. I don't have a driving record, and it looks like this was maybe a missed hearing. So the bond that was put on the KPS is $1,000. So I don't have any other information than that.
Judge, and speaking Mr. O'Brien, he wishes to resolve this matter today.
Do we have any ability to look for his DL?
Yes, I have it here.
Okay.
The documented offer from the state is withholding court cost. Reviewing his driver's license record as of February 22nd.
Yeah.
This would be a first.
A first, okay. All right, so you've heard the offer from the state. It's a withhold court cost. It seems like it's a first offense. If you want to talk.
Yeah, I'm just going to ask him if he wants.
Yeah. What's that?
He wishes to accept the state's offer, Judge.
Thank you. All right, sir, raise your right hand. Go ahead. You're good. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, you can put your hand down. State your name, please.
Robert Matthew O'Brien.
All right, Mr. O'Brien, it's my understanding that you would like to enter a no contest plea to this charge. Is that correct?
Yes.
Okay. And the state's offer is a withhold and court cost. I'll give you 6 months to pay that court cost. Is that what you want?
Yes.
All right, and you understand that by entering into a plea today, you're going to be giving up all your rights as it relates to trial, having the state prove the case beyond a reasonable doubt, and a whole bunch of other constitutional rights that you have as it relates to fighting this case. Is that what you want to do?
Yes.
Okay. All right, so I will find that you have voluntarily and freely waived your rights, all the constitutional rights. I'll enter the no contest plea and give you a withhold court cost 6 months to pay, okay?
Good luck, sir.
Good luck. All right, so the paperwork that I have next, I have two different people's paperwork stapled to each other, and I don't have full packets, I don't think, on either. So I have Kenneth Hanley, which it looks like 2 ad charges, and then I have attached to that a booking report for Colin McLean, and then I have a capias with an ad, an ad charge on him. So, do you guys want to look at this and?
It said no paperwork in the document.
On the plea.
For Colin McLean, so maybe they got you some of the paperwork, but they didn't have.
Yeah, I mean, it looks like looks like they maybe meant to put some stuff in here from Mr. Hanley, but instead.
I don't think it was anything for Hanley, Your Honor. If you want to deal with Hanley's case first,
All right, well, let me do this. Okay, hang on. This is Hanley. This is the other guy. Okay, Mr. Hanley? Do I have a Kenneth Hanley at Paul Ryan or somewhere else?
Paul Ryan, Your Honor.
Oh.
He's coming in as we speak.
Okay.
He's coming in right now.
Excellent, thank you. Thank you. Mr. Hanley?
This morning.
All right, good afternoon, sir. You're here
Judge,
on
we'd
two...
waive formal reading of the charges.
Okay, you're here on 2 ad charges. And as far as, I guess there's a count 1 and a count 2 that I'm looking at. It looks like maybe he's being held no bond. Is that correct?
It's
No
a
bond on
refile
count
of
1.
The 2016 case, and in the refile we added a count.
Okay.
Your Honor, I provided the court the original findings from the 2016 case,
Okay.
where Judge Zakor ordered him to be held no bond upon finding of proof evident or presumption great.
Okay.
I've also attached the probable cause affidavit
Right.
from that from that hearing. Considering that this is a refiling and the second count is made up of the same charges or same allegations from the original PC affidavit, it involves the same alleged victim, I'd be requesting that the court make a finding of proof evident or presumption great, and
All right.
that he be held no bond on both counts.
Let me just read this PC.
Sure.
So to be clear, these two counts that are add charges, are they these two counts from the original PC or just one of them?
Both.
Both. Okay. All right. So let me review this then.
Baby, Charlie 9.
Okay, so I have finished reviewing the probable cause affidavit. All right, so you are asking for a finding of proof evident presumption grade, is that correct?
Yes, ma'am.
Okay, Mr. Reedy, do you want to make any arguments?
Yes, Judge, we would object. That is the highest standard of proof that we have in the criminal justice system. This is a case that I guess is from 2016. I see a notation here in Odyssey that there was no victim contact. So I don't know if that was the reason for the delay or not. But the report itself appears to have been written on April 1st of 2016. And then the only evidence, from what I can see, unless I'm missing something Mr. Linder could point out to me, the only evidence against Mr. Hanley is the testimony of the alleged victim in the case. She doesn't remember exactly how old she was when it started, how many times it happened. Her memory certainly seems to be faulty to an extent. And while I admit that could be a finding of probable cause, to reach the very high standard of proof evident presumption great and hold Mr. Hanley no bond as the state is requesting, I don't believe based on this probable cause affidavit that would be appropriate.
What is holding him on counts 1 and 2? Are there bonds? Are there no
Count
bonds?
1 is another similar count that he's being held no bond on.
Oh, and he's being held no bond?
Oh, I misunderstood. I thought that counts 3 and 4 were the same as counts 1 and 2. That there was a refiling of those two
These are
charges.
add
Count one-
charges.
Count 1 is the same offense as 3 and 4.
Is it the same alleged victim?
That I don't know. I suspect it is, but If you go to BSO Pics, you'll see. That's
Well,
what I'm.
well, I made my argument, Judge, regardless, so.
Okay. This is a tough one. I mean, there's a lot of details in this probable cause affidavit, but there's a lot of details that are also missing. I mean, I think there's certainly enough as it relates to proof evident presumption great for one count. I am a little bit confused as to I mean, there's a lot of allegations in the complaint. I'm sorry, in the probable cause affidavit. So I mean, there's definitely one that is specific. There's a lot of non-specific.
One moment, Judge.
Yep.
Your Honor, I can tell you one count covers the alleged incident that occurred in April.
Yeah, I think there's proof evident presumption great as it relates to that one.
And then
I'm just not sure what a second count would be. I think there's allegations that there could be up to, I guess they say 6, although it doesn't.
And I can, reading from the information, Your Honor, I can tell you it alleges that on one or more occasions between December 1st, 2014 and March 31st, 2016, and then it goes into the specific elements of the offense and the information.
Well, I guess that was from the original information that was filed. And then what was it? No, it was null prost, or
No, I don't, it hasn't been, let me just.
was it no info, or how?
No, it hasn't been at this point. Let me check. It's still pending. Pulling the information.
How is it being ad charged if it's still a pending? Is this the filing of it? I'm just confused.
If we could put this on a brief recall.
Yeah, let's do that. All right, Mr. Hanley, we're trying to figure everything out, okay? So just give us a second. We're going to put you on recall so that we can look into this a little bit further and make sure that I understand the timeline as well as what's going on with the particular charges, okay?
Okay.
All right, thank you. All right, now do I need to address the Colin McLean, or is this just paperwork that got attached by mistake?
No, this is, well.
I didn't even, to be honest, I didn't look at the docket entries. I just looked at the
He
paperwork.
has to be heard, but there might have been a paperwork issue getting the paperwork done in time for him to be heard this afternoon. Well, I'm just going on the docket. It says no paperwork. So.
I'll just remake the paperwork and send it back over and he'll go.
Okay. All right. So should I give this back to you then? This is just what was attached to the last case. Thank you. Okay. All right. Jeffrey, welcome. Jeffrey, welcome. Oh, okay. Well, that would make
He's
sense.
approaching Jeffrey Walton.
He actually, it sounds like that there was a bond posted, so I'm not going to touch anything so that your bond will stay in place, okay? All right, good luck. Okay, Michael Condon.
Mr. Condon, come on up. He's approaching, Judge.
Thank you.
And Mr. Condon declined the service as public defender. And Judge, whenever you're ready, Ms. Taylor is ready to proceed.
Okay, we'll go to her next. Thank you so much. All right. Mr. Condon, you are here on one count of burglary of an unoccupied dwelling armed, one count of grand theft auto, one count of driving while licensed, suspended, habitual, fleeing and eluding at high speed, and reckless driving. So based upon my review of the probable cause affidavit, I do find probable cause. We need to set a bond on count one, and I also have a note here that, is he on pretrial release?
He's out on cases. I don't know if it's bond or pretrial.
Because I wrote it down.
It's bond.
Tell me what's going on, because I wrote this down. Must have been somewhere on here.
Michael no, Ms. Mateo?
She's not in. So I want you to reach her.
Do you have a screen?
All right, just so you know, we can hear everything you guys are saying there. So if you want to have private conversations, it's being recorded and on the record. Thank you.
Yeah, it looks like he's out on bonds. He's got 3 pending felony cases, 1 for grand theft auto, a second case for 4 counts of burglary of a structure, grand theft between $20,000 and $100,000, and dealing in stolen property.
All separate cases that he's out on bond on?
No, there's a grand theft auto.
Yeah.
Then everything else I told you about is the second case, and then there's a third case with a charge of grand theft auto. So 3 separate felonies.
On bond on all of them?
I believe so, yes.
All right, give me case numbers.
18-11358 CF10A.
Yep.
18-12754 CF10A. Wait. 18-11460 CF10A.
All right, and can you just confirm for me as an officer of the court that he's out on bond on each of these cases?
One moment, Judge.
How did that happen?
That's a good question. From what I can tell, he's out. He bonded out on all those charges.
Wow. Okay. All right, sir. Well, we will get to those 3 cases in just a moment. And just so you know, I will be revoking bond on all 3 of those cases. You will be held no bond on all 3 of those cases. I do have to set a bond as it relates to count 1 here, the burglary of an unoccupied dwelling, as well as talk about bond on the other counts. State, what is your recommendation?
Considering this was a home and his pending cases, $25,000 on 1 and $5,000 on 4.
All right, and the as it relates to the other bonds that are listed, the grand theft auto, driving while licensed, suspended, habitual, and reckless driving?
I was making those recommendations in consideration that the other bonds are left in place.
Understood. Okay. All right, Mr. Condon. So you can go ahead and when you're ready, you can unmute if you want to talk to me, because right now the microphone is on mute in the jail. And what the state is recommending for bond on count 1 is $25,000, count 2, $1,000, count 3, $750, count 4, $5,000, count 5, $100. And keep in mind that, like I said before, I'm revoking your bond on all 3 other cases that you were out on bond. So those are going to be no bond. So if you'd like to tell me anything about what the state is recommending for bond and what you believe I should set bond at, I can do that now. When you're ready, you can unmute the microphone and you can raise your right hand and I'll swear you in, okay? You don't want to talk? Okay, understood, no problem. All right, well, I will accept the state's recommendation then, and I will set bond at $25,000 on count 1, $1,000 on count 2, $750 on count 3, $5,000 on count 4, $100 on count 5. I also need orders revoking bond on cases 18-11358 CF10A, 18-12754 CF10A, 18-11460 CF10A, all to be held no bond.
And just for the record, Judge, the Office of the Public Defender does represent Mr. Condon on all 3 of those cases.
Okay. All right. Well, Mr. Condon, get in touch with your public defender then, because you'll be sitting in custody. They'll get a court date for you. There you go. Okay. Let's go back to Miss Mateer.
Ms. Mateer's approaching, Judge. She's here at Maine. Come on up, ma'am.
All right. Hello, Miss Mateer. Welcome. You are here on one count of aggravated assault with a deadly weapon. Based upon my review of the probable cause affidavit, although it's a bit unusual, I do find probable cause. Let's talk about bond. State what's your position on bond.
I was going to be requesting a $2,500 bond, no victim contact with Ronald Marchetti.
Okay. All right. Go ahead, Mr. Romero.
Judge, this is unusual. I'm going to be asking for either releasing Ms. Mateer on straight ROR or on a pretrial release standard. My understanding, Judge, is Ms. Mateer, and speaking to her, I don't know if it's reflected in the PC affidavit, she's the one that actually contacted the police. The alleged victim in this case does not live at the address where she's living. She lives there with a roommate. I believe that was a friend or acquaintance of the roommate, in which they got into an argument, and the alleged victim, according to the PC affidavit, first threatened to throw a chair at Ms. Mateer, and that's why she contacted the police. And then I believe the round pot came into play. Having said that, Judge, she's 22 years old, been here her whole entire life. She is a single mother, basically raising 2 children. Right now, the 2 children are with their father. She's living at those premises in Lauderdale Lakes, and she pays approximately $550 per month. She also works, Judge. She works at a company called Advantage Reserve, which she books hotels, and she doesn't know whether or not she's going to have a job after this because she's been here overnight. Judge, we're going to be asking, like I said, to either consider releasing her ROR or on standard pretrial release, Judge.
Okay. Does she have priors or any failure to appear cases?
I didn't see anything, Your Honor, but the only thing, I can only go by what's in front of me, and they have the victim notification form from the Broward Sheriff's Office.
Okay.
And Mr. Marchetti is listing this address where this occurred as his residence.
I see that. Okay, I do see that. All right, and just so you know, Mr. Romero, the things that you talked about are not reflected in the probable cause affidavit.
I would probably imagine they wouldn't be.
Right. Okay. All right. Well, here's what I'm willing to do. If she has no priors, I'll let her out on pretrial, but there's going to be the issue of where is she going to be living, because
That's the thing, and I did give her a heads up.
Yeah.
Even though he doesn't live there, I believe that he's just the boyfriend or the acquaintance of the roommate. If he's there, I know the court order pertains to her. So if she goes back and he's living there, she's going to get rearrested. That's what I told her. I told her not to put herself in that position. I told her to try and find a separate place. But what I will be asking, Judge, if he is there, to sign a property order so she can go back with law enforcement to retrieve her property.
yeah,
And
I mean,
she's going to try and figure out where she can go.
I don't have a problem, of course, if it comes to that with the property order, and I don't know if you want something signed today or if you're going to have to get something signed, I guess, given the circumstances, but it does say here in the victim notification the address, which is the same address that's listed for her. So I don't know what's going on as far as who's living there, who's not living there, but I am going to it's going to be a pretrial release. So, ma'am, because you have no criminal history and no prior situations where you failed to appear for a court date that we found, I'm going to give you an opportunity to basically be on pretrial release. It's a supervision program so that you don't have to post a bond, okay? But part of the conditions of pretrial release is that you can't have any contact with this person. So if they are living or staying at that residence, then certainly it's going to be a violation if you're going to be in contact with them. So you have to just be smart about it. And if it means you have to find a place for a while until you can kind of get to court and work on these issues, that might be something that you definitely need to consider, okay? But I'll let you out on pretrial release.
Is that standard pretrial?
Yeah, I'll let her out on standard. That's fine. No victim contact.
And after this case, we can go back to Mr. Hanley's case.
Okay. There you go. Thank you. Okay, Mr. Hanley, if you want to, where was he again?
Paul Ryan.
Thank you. All right, come back up, sir.
Okay.
All right. What did we find out?
I spoke with Assistant State Attorney Amanda Graham. She is
Yeah.
handling this case. And it's as I suspected. The reason charge 1, the 2016 case, he still has that no bond hold. The state is not going to null pros that case until he's arraigned on the 2019 case. It's just a procedural matter. But that ultimately will be null pros. But it is, the charge in that case is the same charge as charge 3 before the court. I believe that's the
So, to be clear,
yeah.
on that case, there's never been charges filed, or there were charges
it's
filed?
been going on. What happened was, Your Honor.
Why would it then need to be refiled?
Apparently, there was a based on deposition testimony.
Okay.
Ms. Graham decided to file the second charge. So I believe to keep them together, she's just refiling it with both charges together. Since it's
Okay.
a continuous course of conduct, I believe.
Okay, so it's okay. Well, I guess that gives some sort of explanation. Okay. All right. Anything, Mr. Reedy, further as it relates to the I'm still confused as to, I guess, so count 3
Count 3.
is what date?
That's the April. The information that covers the incident that occurred in
The
April.
laundry room?
Yes, ma'am.
Okay. So, and what is count 4?
4, it's made reference to in the report, but I can advise the court there was testimony that was taking a deposition.
Yeah.
And based on that testimony, Ms. Graham decided to file the additional charge. So some of that evidence wouldn't necessarily be before the court. It was based on victim testimony.
Yeah.
Your Honor, based on
I just don't know how to set a bond on that.
And Your Honor, is the court inclined to find proof evident or presumption greater?
For the laundry room, yes.
We would just, on 4, Your Honor, we would be requesting a $50,000 bond.
I think you have to release him, Judge. I don't think you have probable cause in front of you right now on count 4.
Well, is he gonna, if, let's say that I would agree with you on that, is he gonna want an ROR? Because he's not gonna get credit on that.
I'd ask for an absolute minimal bond.
Wait.
Don't say anything, Mr. Hanley. You should not be discussing this case with anyone but your attorney.
Okay, so just to kind of clear things up for the record, as it relates to count 3, and I won't read the charge, I am finding proof evident presumption great. I am going to hold him no bond based upon the information that I've reviewed in the probable cause affidavit for the laundry room incident. I'll call it that. As it relates to count 4.
One moment, Your Honor. And Your Honor, first of all, I would argue that there is probable cause based on the state filing charge. For the defense to ask the court to find, the question is whether he's lawfully being held. He's lawfully being held because the clerk's office, pursuant to statute, issued a not-in-custody capias upon the state filing an information. For Mr. Reedy to ask the court to find no probable cause would be akin to essentially a motion to dismiss, to say the state had no basis to file the information.
Yeah, I mean, if it's a filed charge, I don't think it's a matter of a probable cause issue. I think it's a matter of what do I set as a bond.
How can you know what to set as a bond, Judge, if you don't know what the count 4 is about?
Well, I mean, listen, there's no question that there are other allegations in this complaint, but do I know which one it is, or if it's something else, like Mr. Linder said, as far as deposition testimony? I mean, he's going to be held no bond on count 3. I mean, we can talk about numbers. I think this is going to be academic, but, you know, we can talk about it.
And that's why I think the court could also rely upon the charging document. If you'd like, I could provide you with a copy of it. I essentially read from it before.
My only question is, though, is that how do I determine bond on that?
Well, certainly if the court does not feel that you've been given as much detail as in the other case, that's something to take into consideration in setting a bond. The nature of the offense is something to take into consideration. If Mr. Reedy wants to present his financial resources tied to his community, I mean, it's no different than any other case when it's the different factors that the court's to consider. It's just what does the court have in this case, or how much of each factor.
Well, what was your recommendation if I'm setting a bond?
Based on the nature of the allegations, it was $50,000.
Okay.
And no victim contact on both counts with PH.
Okay, so there's definitely going to be no victim contact. As it relates to count 4, Mr. Reedy, what is your recommendation, or if you want to speak and ask some questions, it's up to you.
No, I mean, he's going to be held no bond, so his financial situation isn't really relevant at this point because he's not going to be able to post a bond if he had millions of dollars. So I would ask the court for a $1,000 bond on count 4 in light of the fact that there's nothing presented by the state that I even think really gives rise to a probable cause argument. We don't know when this happened. I mean, the information says sometime between December of 2014 and March of 2018. So, I mean...
But I can't... probable cause is not for me to determine here because there's a filed charge. So it's not an issue of probable cause. It's just a matter of I need to just set the bond. So what is your recommendation? $1,000?
Yes.
Okay. Yes. Did you want to say something?
One moment, just because... I just want to look at this again real quick. I would note, there is reference to previous allegations, Your Honor.
Yeah.
And clearly they were before the April incident because she said that was the last time. And I think that's part of what makes up for the time span that's stated in the information. And there are specific allegations as to what occurred. And I'm referring to the paragraph that starts with during the interview.
Okay.
Now, yes, it is true she did not provide dates, but stated where each incident occurred. She mentions the location where the van in one of the occurrences was parked. She mentions the city where one of the other, and she couldn't give a date, but stated it happened last year. So there is some, is it, and that's why I can understand the court not finding proof evident and presumption great. But to set a $1,000 bond, I think there's more than enough detail that at a $1,000 bond on a punishable by life offense with these type of allegations would not be appropriate.
All right, what I'm going to do is this. I'm going to put a bond in the amount of $25,000, no victim contact. It's kind of academic because it's going to be a no bond hold on count 1 based upon proof evident, presumption great finding. And, of course, that's without prejudice for you to seek a bond in your division, from your division judge. You do have a court hearing tomorrow morning. So you're going to go to court tomorrow morning at 8:30, okay? All right, good luck, sir. Does this have any information that needs to be shredded? Or can I recycle it?
You know,
the name is on there.
In an abundance of caution, you might want to keep it with your paperwork just in case, for some reason, there's a review of this hearing and they want to know what the court considers.
Okay, no problem. We'll attach it to that. Okay, James Boehm?
He's here, present, Judge and me.
All right, good morning, or I'm sorry, good afternoon to you, sir. You are here on 1 count of burglary of an unoccupied dwelling unarmed, 1 count of grand theft, $300 to $5,000. Based upon my review of the probable cause affidavit, I do find probable cause. Mr. Linder, what's your recommendation as to bond?
Your Honor, I'd be requesting a $7,500 bond. While it was a hotel, it was someone's room in that hotel where they would expect complete privacy and safety from having strangers going into their room. His criminal history as far as Broward, 2015, DUI, that was his second offense, leaving the scene of an accident, 2013, DUI with an enhanced breath 02 and a DUI 01, I would admit that I would argue that the evidence is strong against Mr. Bohm, and he admitted to doing this, claiming he needed to borrow the victim's phone.
Okay, Mr. Romero?
Judge, and speaking of Mr. Bohm, he's looking forward to having his day in court. He's disputing these allegations. He basically told me that he was cooperative with law enforcement. He basically borrowed the phone. He doesn't know why the victim didn't tell the police officer that he actually lent him the phone. He insists that he didn't take the phone, he borrowed it. Having said that, Judge, he's 51 years old, been here his whole life right now. He has some health issues going on. He's applying for disability, but there's no one that's going to be able to afford a post-monetary bond. He's asking me to ask the court. He's requesting an outright ROR on this case, Judge.
Your Honor, I would just know, I know the court's aware of this. I don't believe Mr. Romero is aware of this. But when he was first confronted, he told the officer he did not take the man's phone in the other room. Once he was, and essentially I think he was bluffed and told that, well, there's surveillance video of it, he then decided to go to his room, take the phone, go back to the officer. I don't call getting caught as being cooperative.
Judge, he said he didn't take it. He borrowed it, and there's a difference. If an officer asks me, did you take something, and I in fact borrowed it, I'm going to respond, no, I didn't take it.
Well, I'm not the jury, so I'm not making those determinations. But as it relates to bond, what I'll do is this. On count one, I'll give him a bond of $1,000. On count two, it'll be $1,000, $2,000 bond. And no victim contact. Okay, Michael James.
Exactly.
Come on up, sir.
All right, good afternoon, sir. You are here. One count on distributing or delivering cannabis, a count of distributing or delivering THC, and a probation violation issue. The probation violation issue has you a no bond hold. However, you do have a court date tomorrow at 8:30, so you're going to go to court on that. So here's my conundrum on the other two is it's distributing charges, but there's no testing on either substance.
One moment, Your Honor.
There's an alleged admission of the drugs, but nothing specific.
Yeah, that's fine, Your Honor. I'd ask for 24 hours.
Okay. The only issue is going to be, I guess, he's not going to be brought back in 24 hours because he has a hearing tomorrow.
Well, we can reset it for the PM. I imagine he'll see his judge tomorrow morning.
Okay. I mean, however that, okay. So what I'll do is this, let's see, no probable cause, let's see, continued for 24 hours. Counts 1 and 2. Okay. Here you go. Thank you. All right, Wayne Zafir.
Come on up, sir. He's approaching, Judge.
Okay, you are here on one count of possession of a controlled substance without a prescription and one count of drug paraphernalia. I definitely see probable cause for the drug paraphernalia. I think maybe certainly there wouldn't be a prescription for alleged cocaine.
Yeah, and that's, Your Honor, if you look at the very last sentence of the report,
Yeah.
I know it got put down, entered in as possession of controlled substance. clearly based on the plain language, he says he was arrested without incident and charged with
possession of cocaine. It looks like maybe they just typed it in a little bit.
That's just how it came out.
Okay. Well, I mean, there is I did see that there was I'm pretty sure I saw that there was a test, Valtox positive. So, all right, I'll find probable cause. Let's talk about bond. See a candidate for pretrial or no?
Judge, we're just going to be requesting a phone order.
Okay, all right. So I'll leave the bond at $1,000 on count 1. No requirement for bond on count 2, and I'm happy to sign a photo order.
No, phone order, phone order.
Phone order. Sorry. Okay,
Thank
phone
you.
order. I'm happy to sign that too. All right, Ryan Sanders.
Mr. Sanders, come on up, please. He's approaching, Judge.
All right, Mr. Sanders, hello to you. You are here on 1 count of possession of cannabis, 20 grams or less, and 1 count of driving while license suspended, third or subsequent offense. So based upon my review of the probable cause affidavit, I do find probable cause for the cannabis. The driving while license suspended, it says, I think, arrests. It says something weird on here. 2 prior arrests for driving while license suspended. I don't know that arrests count as predicates for third or subsequent offense.
One moment, Judge.
And we don't have a DL?
Do you have one?
Okay.
I mean, I'll pull his driving record because I see multiple priors for DWLS.
Convictions or withholds?
No, convictions.
Okay. Tell me what you see.
Just out of Broward, he was convicted November 5th of last year on a DWLS. Then there was a conviction in 05. Again, I can pull his driving record to make it official.
Judge,
Yes.
before we go any further, he wanted to see if his bond's been posted.
Oh,
Can we ask confinement status?
of course. Do we have Mr. Sanders' bond being posted? Yep. Nope.
He said someone's going to be posted.
Do you want, okay. So you want me to leave it like this? You want me to find probable cause and leave it? Is that what you're requesting? I mean, I think based on we know there's 2 in Broward, 2 priors in Broward.
Judge, right now, leave it, because if for some reason
Okay.
it gets changed, he doesn't want to be held up where the family has to go back to the bondsman
Sure.
or something.
Okay. I'm happy to leave it. So there's going to be no requirement to post bond on count 1 and count 2 at $750. Good luck, sir. All right. Alex Lewis Innocent.
Mr. Innocent, is here present, Judge, I mean?
Okay. Hello, sir. You are here on 1 count of battery, and it's causing bodily harm. And then you also have an out-of-county hold from Osceola County. So as it relates to the battery, based upon my review of the probable cause affidavit, I do find probable cause. Just so you know, your out-of-county hold, I'm sure you've already been told, but that has a bond of $3,500. So you do have a bond on that. I can't obviously otherwise address that. But as it relates to count 1, anybody want to speak about bond?
Not the defense, Judge.
No?
No, that's from the state.
Okay. All right. So what I'll do is I'll leave the $1,000 bond in place and order no victim contact. And hopefully he can bind it out. Good luck to you, sir. All right. David Townsend.
Mr. Townsend is here approaching, Judge. He declined to serve as his public defender.
Okie
Mr. Townsend,
dokie.
come on.
All right, Mr. Townsend, you are here on 1 count of DUI, third offense within 10 years, 1 count of driving while license suspended, 1 count of refusal to submit to a DUI test. You also have a ticket for no insurance, and then also a ticket for standing or parking or prohibiting. Well, in any event, it's a ticket I'm not dealing with today. So based on my review of the probable cause affidavit, I do find probable cause. So, State, what is your position on bond? So So, sir, do me a favor. Mute the microphone until it's time for you to speak to me so that we can hear, because it's very loud from there. And then once we have the recommendation from bond from the state, I'll ask you what you would like to do, okay?
Okay, I can do it.
No, just hit, mute. Yeah. Great, perfect.
I just want to make sure that this is in fact a third within 10.
I saw that there was,
I don't believe it is.
yeah.
And the
I think there
reason-
was two that listed, did it say 2008 or something like that?
Yeah, that's the thing. It isn't because both of them aren't within 10. It's because it looks, from what I can tell, the most recent conviction, according to the
Oh,
officer's
yeah, it wouldn't be
report,
within 10.
is 7/24/2008.
Yeah, it wouldn't be,
Which
okay.
would be outside of 10, so that doesn't bring in the first
So
one.
then is it
It'd be
still?
third outside of 10.
Third outside, that's
Which is
a
not a
first degree
felony.
misdemeanor?
Yes.
Okay,
So
so it's
you're-
third outside of 10,
So in
first
light of,
degree
I'm sorry.
misdemeanor.
In light of that, Judge, just make sure there aren't more than 3. No, that's it. Yeah. In light of that, Your Honor, I would be requesting a $2,500 bond. Should he post his bond, that he be supervised by pretrial with a TAD monitor, no alcohol or intoxicants, and no driving until further order of the court, and random testing.
Okay. Okay, sir. So as it relates to the count 1, what I'm doing is I'm finding probable cause for a first degree misdemeanor, driving under the influence as a third offense outside of 10 years. Okay, I don't want you to say anything about the facts of the case or anything like that. I just wanted to let you know that. The state is recommending a bond of $2,500 with pretrial release, a TAD monitor. That's the alcohol monitor, correct?
Yes.
It's a monitor type thing that can tell if you're having alcohol. No alcohol or intoxicants, no driving until further order of the court, and random testing through the pretrial process if you are able to bond out. Can you make a $2,500 bond? I think that's a very reasonable bond as requested from the state. Okay, so go ahead. You can unmute yourself and just real quick, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can put your hand down and just talk to me about the financial circumstances, okay? Because everything you're saying is being recorded and can be used against you. So you don't want to talk about the facts of your case. Go ahead.
Sure, I mean, about last night?
Okay, we don't want to talk about the facts of the case. I'd like to
Okay.
hear if you can post a $2,500 bond.
Yes, I can.
Okay, so what I'm going to do is I'm going to give you a bond of $2,500 on count 1. On count 2, I'm going to give you a $100 bond. On count 3, I'm going to give you a $100 bond. Not going to require any bond on count 4. That'll be ROR. And the ticket is not something that I set a bond on. You're going to have a total bond of $2,700. If you're able to post that, pre-trial release with a TAD monitor. Okay, that's the alcohol monitor. No alcohol or intoxicants while you're on pretrial release. No driving without further order of the court. And you're going to have random testing for the pretrial, okay?
Sure.
Okay. All right. So we're going to fill out all that paperwork, and you'll have to post the it's a total of $2,700 for the bond, okay?
Sure.
All right. Good luck to you.
Thank you.
Okay, Dalton Fisher.
Mr. Fisher is here present, Judge Amin. Come on up, sir. He's approaching, Judge.
Okay. Mr. Fisher, you have 2 counts here. Let me look briefly. Thank you, ma'am. I will sign that in 1 second. All right, so we have some not in custody KPS charges. One is dealing in stolen property. The second one is false verification of ownership to a pawn shop. So there's already been probable cause found. And the bonds that were originally set by the judge are in the amount of, I can't tell. Is this 30?
This is Dalton Fisher, Your Honor?
Yeah, 3,500 and 1,000. Why do I have paperwork about probation though?
Well, I don't know about that. These are not in custodies.
Yep. I have paperwork here that
Yeah, I see
shows
what
that
you're
he's on
referring
active
to.
probation.
He is, Judge.
Okay.
Oh, here's
Mine-
the thing. Your Honor, they attach that anytime I believe that there is a current DOC matter. But it would look like he got put on probation July 6, 2018, and these incidents occurred December 16th in 2017.
Oh, okay.
That's why he doesn't have a 94806.
Got it. Okay. All right. So no issue as it relates to the probation. Want to talk about bond?
Yes, Judge. As you could see and you heard, he's been on probation all this time. From what he advising me, he's built up a good rapport with his probation officer. He's reporting with no problems, Judge. So considering he's currently being supervised, Judge, I'm going to be asking on these nonviolent offenses, since it predates it, to consider an ROR on his behalf. Obviously, if he misses court, if he doesn't come to court, one, there'll be a warrant issued for his arrest, and two, it's probably going to be the basis of a violation of probation, Judge. So at this time, I think there's things in place, so that's why I'm requesting an ROR on Mr. Fisher's behalf.
Yeah, I just checked to see if there had been any violations of his probation. At this point, there haven't been, so I don't have an objection.
Okay. All right. Your lawyer made a great argument for you. The state's even agreeing with him, so I'll ROR you.
Good luck, sir.
Okay, thank you.
Keep on doing well on probation.
Okay. Evan Sides.
Mr.
I'm sorry. Here you go.
Yeah, because I was.
And I have a note that he's out on bond.
Yes.
Yes, Your Honor.
Uh-oh.
As a matter of fact, Your Honor, he was placed on pretrial on the 8th of this month, and we have not seen him since.
Uh-oh.
We've actually sent the field team out to where we thought he resided. He never reported. So today we saw him, and not only did he not report, but now he's picked up this new law violation. So I'm going to ask that his pretrial status be revoked in the 2 cases that he's out on.
And, 2 cases, okay.
Yes, ma'am. A misdemeanor petty theft.
Oh, I got it. Okay, I see it in
felony
the.
grand
It's
theft.
written into the probable cause affidavit. Okay, tell me what's going on.
Your Honor finds probable cause for the burglary?
Yes, I'm sorry. Based upon my review of the probable cause affidavit, I did find probable cause.
Yeah, Your Honor, I mean, I'm at fault also because, frankly, against my better judgment, I told the court I had no objection last Friday to a pretrial release on a grand theft when he was arrested on a capias on a pending petty theft. But figured give him a chance, and now he's back after breaking in, trying to break into someone's home. Didn't even show up to pretrial. So, Your Honor, I'm requesting a $20,000. I'm sorry. Also noting, the resident was home when he broke onto her property. I'm requesting a $25,000 bond.
Okay. All right. So, Mr. Romero or Mr. Reedy, whoever would like to speak to me, I'm happy to hear from you.
Judge, my first question is going to be, is the court taking any action on the cases he's out on?
Yes, I am going to be revoking pretrial services on both cases. It's going to be no bond holds.
Considering, Judge, at this time, since he's going to be held no bond, he's going to have to go in front of his division judge for relief anyway. At this time, nothing to add from the defense.
Okay. Well, then I'm going to grant the state's request for a $25,000 bond, no victim contact. And I am going to be revoking the pretrial on 19256 MM20A and 19297 CF10A. So those are signed, no bond holds. Good luck, sir. All right. Agli Kaka.
He's here, present, Judge, at Maine.
Bond?
He's approaching. He declined the services of public defender.
Okay, so sir, your bond is actually posted. So I'm going to leave everything in place so that it doesn't disrupt that. Good luck to you.
Thank you so much.
All right. Okay, what's next?
Tantiana.
Okay.
I have Watson and Christopher.
Okay. Okay, so this is Christopher Watson, I guess on page 2. Yeah.
Yes, ma'am. Yes, ma'am.
Okay, so I have no, tell me what's going on, because I wasn't given this docket ahead of time to look up anything.
I'm going to look at him just 1 second to finish the order. Your Honor, an information has not yet been filed.
Thank you. Okay.
He's entitled to an ROR on these charges.
Okay.
I would just ask that the court can advise Mr. Watson. I believe there was a no contact order issued as part of this case, and yes, and I would just ask that if you'd advise him that is still in place.
Okay. All right. So, Mr. Watson, I am going to grant an ROR, release on recognizance, on it looks like there are 3 pending charges, correct?
Yes.
All right, 3 pending charges. Okay, so there's no requirement for you to post a bond. You're going to get out. However, if you don't show up to court, if you pick up new cases, and if you have any contact with the alleged victim in this case, those 3 things are going to create a lot of problems for you, okay? So make sure that you steer clear of that and that you come to court when you have a court date, okay? If you have a court date, all right?
Yes.
All right.
So I'll be R and R on all charges?
Yes, so ROR on all 3 charges, but the no contact with the alleged victim is still in place, okay? So don't talk to them, don't reach out to them.
No problem, thank you.
There you go. Okay, who's next?
I have Nelson Dwayne.
All right, hang on. Let me find him. Nelson, is that a misdemeanor?
Yes.
Okay. Okay, so is this just a second look because he hasn't bonded, or?
Yes.
Okay. I don't have any information on this, so.
Hold on.
Oh.
We're just looking up your case, okay, sir?
Yes, ma'am. Oh, Thomas, this is you. Thomas, this is you.
Yeah, no, I don't have an offer, Your Honor. It's a trespass. It involves someone's vehicle, but frankly, I think I don't know that that's going to,
Stay that way?
well, no, I don't think it's going to be a major issue for Mr. Nelson at this point. When he was arrested, he had a felony VOP.
Okay.
He pled out the VOP. He's county sentenced to life skills with an expected release date of June 18th. He's got more than enough time to go in front of his assigned judge on the misdemeanor
Okay.
and get that worked out.
Okay. So here's the situation, sir. It's my understanding that you are county sentenced on another matter. So you're going to be in custody for a little bit on a probation case. There's a couple things that you can do. I mean, there's no offer right now from the state attorney's office because realistically you have time to go before your division judge and either get an offer if you want to resolve it then, or you certainly can fight the case. So, you know, you probably might want to speak to, it looks like you have a public defender assigned to this. You might want to speak to the public defender, get some advice on this before you do anything with this. Because even if we were to change a bond or not require a bond, then you wouldn't be getting out.
Yes.
Okay, so why don't you do this? I think probably the best idea is for you to have a talk with your public defender when you all have a chance to do that, since you're going to be in custody for a little bit on the other issue. And that way you can, you know, make a decision as far as what you want to do. You don't have to have any pressure on you at this point for deciding, okay?
If I may advise, Mr. Nelson, Your Honor, our office just filed a motion to withdraw because we currently represent his co-defendant on a felony charge. So as soon as that motion is heard, Mr. Nelson will be appointed probably regional conflict counsel or someone else to represent him, and we can have the discussion with whoever that attorney is going to be.
Okay. So did you hear that? So the public defender's office just filed a motion to withdraw because they have a conflict because they represented your co-defendant. However, we do have conflict regional, which is another type of public defender style office that is probably going to end up being appointed to assist you with this. So realistically, you're going to have an attorney. It just might not be the public defender's office. It's going to be someone else, okay? All right, but just sit tight, talk to them when they get appointed to you, and that way you can make an informed decision about what you want to do.
Okay.
All right, good luck, sir.
Good luck.
Thank you. Thank you, Alan.
Okay, what about, let's go back to this second look felony docket. Where is, I guess we'll just go from starting on page 2, Maine's Bonnet.
North Broward.
Okay, North Broward. All right, it's an ROR hearing.
this is,
What's going on?
I believe the information is filed today. I just want to make sure.
All right, so we're just checking out to see if they filed charges, okay?
Yes, the information was filed today.
Okay, so the state attorney's office just confirmed that the information was filed today. Is there a bond set or?
Yes. He's got a $1,000 bond on possession of cocaine, and I can tell you that. Yeah, I can tell you he's been before, not just his judge, but multiple judges. At first, the case was before Judge Tobin Singer, for whatever reason, and I don't know if it was Mr. Bonnet's choice. Both sides agreed to have him transfer out of drug court.
Okay.
So,
All right.
but he should be scheduled. He should get an arraignment date within the next few days now.
Okay.
Our office does represent it.
Okay. All right, sir. So here's the thing. They filed charges today. Was it both charges filed?
Yes.
All right. So there's a possession of cocaine and possession of drug paraphernalia. They're going to set you for an arraignment soon enough, so you'll be going to court. You are no longer in drug court, so you'll be in a regular division. And right now you have a bond of $1,000. Okay? You're not saying, yeah?
Judge.
Okay. Okay, sir. All right, so good luck to you, and you'll see your judge soon, okay? All right, have a nice day, sir.
Okay.
And now, as far as these counts, do I need to actually fill out that the bond is set because I denied the ROR even though he has bond set? Do I need to refill that out?
I don't think so.
Okay. Okay, let's go to the next one. Sean Lundstedt.
All right, Your Honor.
Hello?
Hi.
Hi.
Okie dokie. We're taking a look here to see. This says the arrest date was 3/11. I'm guessing, is that right or wrong?
That's correct.
Yeah.
This
For my
is just the
birthday.
second look you're on. The rest are second looks.
Oh, because it says ROR on here.
Yeah, they all say that, but that's not what they
Understood.
are.
Okay,
Unless you
all
want
right.
to, unless you want to ROR.
Get
we
an
wouldn't
ROR
stop
right
you.
now, I would love you forever.
All right, well, hang on. Let me find out what's going on first. Okay, so it's a grand theft
Sure, sure.
count. What is the current bond that's set?
It would be
It was $1,000,
$1,000.
which I can't get a hold of anybody. I can't pay it. It's been a nightmare to get on the phone. My PIN, it's just been a nightmare. And I
Okay.
don't have it on me.
You
So-
have the phone numbers, though?
No, I have one phone number, and one person said they'd do it, and they never did it. So,
Okay.
Your Honor,
so I've been here 3 days.
I know. Hang on one second.
I
Mr.
remember
Linder
this
wants
now.
to say
I
something.
think the issue Judge DeLuca had, and if I recall, he was ready to put her on pretrial.
Yeah.
There's a Deerfield Beach address on the booking sheet. There's a Port St. Lucie address on the probable cause affidavit.
My
She
license.
was told, I live at this place, I live at this place. Then finally it comes out, she doesn't live anywhere, she's homeless.
Okay.
No,
And
I
Judge, that,
I live with I can live with my
Hang on.
dad.
Just hang on one second,
I'm
okay?
just telling you, this is the information that came out, and that's why Judge DeLuca at that point said, I don't have confidence releasing a pretrial where I'm hearing all this different information.
Okay. So why don't I do this? Raise your right hand.
Mm-hmm.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right. So there's been some issue. You can put your hand down.
Okay.
And you don't have to tell me anything if you don't want to, okay? Because remember, everything is being recorded. They can use it against you. You know the drill, okay?
Okay.
So your bond right now is $1,000. I understand that you can't make that bond. You haven't been successful at trying to get someone to assist you with that.
Correct.
Where are you living? Let's try this again.
I'm currently living at my dad's,
Where does Dad
which is in
live?
Port St. Lucie. But I've been living down here for a couple of weeks at friends off and on. So basically, I've been a little homeless for 2 weeks. So off and on for 2 weeks. So
Okay.
I live at my dad's. I have a current address in Deerfield Beach still, and I'm still.
But what's that address in Deerfield Beach? Is
That
that a friend or?
No, that's my place. I'm still trying to. It's in the process of an eviction, so.
Okay. All right.
So, I mean, I can use that address, but.
Well, if you're not going to be there, that's going to be a
My
problem.
stuff is there. My stuff is there.
Okay. And what is the situation as far as priors or failure to appear cases or anything like that to where I should be concerned with that?
I'd have to check because honestly, I don't know that we got that far into it because, like I said, Judge DeLuca was ready to have her go to pretrial. It was
Yeah.
I mean, I can tell you.
Well, you probably shouldn't.
I can look it up. Okay. Let's see. There hasn't been an arrest in Florida since 2014.
Okay.
That's all I can see right now, Your Honor, at this point.
So if I were to release you, where are you going to be staying?
I'll go to a friend's house. Because, well, I don't even know where I am. In Fort Lauderdale right now? Is this Fort Lauderdale?
No.
I'll
You're
find
like in
that out.
Pompano, right? What is that considered? Pompano?
Yeah, it'll be
She's
in
in
Pompano.
Pompano.
It'll be
Okay.
in Pompano.
What would that address be? Because here's the problem. We have to be able to communicate with you to get you court dates.
Correct.
And, you know, in the event that charges are filed and you have to come back to court. And
Right.
if we, and also when, as it relates to, if I'm going to release you, I have to figure out some way to make sure that you're going to come back.
Correct. So, 5301?
So you have an actual address.
5301 Northeast 17th Avenue, Pompano. I don't know that zip code though. 33.
And whose place is that?
64. Herman Lindsay.
Okay, is that a friend, a family member? Who is that?
A friend.
Is that the person who was supposed to post the bond?
Yeah. And
All right. Yeah. All right. Well, I will give you a chance, okay? So I will put you on pretrial release. You are going to report to pretrial after you are released from the jail. If you do not report, then they will violate you and come back, and most likely you will end up getting some sort of no bond or other very high type of bond hold. So you definitely need to go to pretrial release. What's
So I
that?
have to come back then tomorrow? Like the next day?
No, so the way it works is once you get released, they'll give you instructions depending on the time. I mean, right now it's 2:12, so assuming you're probably not going to get out while it's open today, they'll have you report first thing in the morning. But follow the directions that you're given. See, right there, boom.
Will I get out today?
Yeah, so
Listen up.
you're going to be staying in Pompano because you have to stay in the Tri-County area for us to monitor you, okay? So you'll be on pretrial release. I'm going to give you a chance, okay? Please don't prove me wrong, okay? Come back to court. No one's saying that you have to plead guilty or anything like that. You just got to come back to court to deal with these charges, okay?
Okay.
All right? So I'm going to release you. I'm giving you a chance, all right?
Thank you.
All right. Here you go. Good luck, ma'am. So this isn't a motion for ROR, though.
That's what he said in the document.
I know, but this is a second look, correct?
He says second look on.
Yeah, I know, but there's no actual motion for ROR, so I'm just going to cross that out. And pretrial release. Okay. All right. The next person I have is Mark Olea.
He's approaching. Judge, he's here at Maine.
Okay. All right, Mr. Olea, what information can y'all give me?
Your Honor, one thing I can tell you, and this is secondhand information, I believe it was Mr. Olea's father who came by the courtroom yesterday. I believe he spoke with the public defender that was present yesterday, Mr. Hill, and I believe his father had some concerns about Mr. Olea's drug use. My understanding was his father was not going to be bonding him out based on his concerns.
Okay, so we know Dad's not going to bond you out, sir, so that's one bit of information at least we have. What are his bonds currently set at?
I believe they are
3,200.
1,000 on 1 through 3 each, 100 on 4 and 5.
Okay, and what is his priors or failure to appear situation?
One moment, Judge.
Yep. Is this a drug court case or no?
It may end up being.
Got it. Okay.
What's that? Yeah.
Hi, how are you?
Still going around like that. Not showing any priors, Judge.
Okay. All right. Well, I mean, I'll put him on pretrial release.
That's what we're asking
Your
for,
Honor, I would
Judge.
ask for random testing. My concern
Okay.
in this case is
Great, no
specifically
objection.
the fentanyl.
Is what?
The fentanyl.
Yep. All right. So what I'll do is this, sir. You're not going to have to post any bond. I'm going to release you to pretrial release, okay? But you are going to have to undergo random testing. So make sure that you're clean, or else it's going to be a violation of your pretrial, okay?
Okay. Thank you. You're gonna be released today, so you have to show up there tomorrow first thing in the morning. Okay? Just follow the map.
All right. Good luck, sir. And that's just regular pretrial. All right. Brandon Ellis.
I believe he's in, which facility is he in? Not at Maine, though.
I think he bonded this week.
Okay. All right. So we don't need to do that.
Oh, okay, nice.
All right. And then I have Reginald Foster.
How you doing, Judge?
Hi.
President Maine, good.
Okay. All right. So tell me what's going on with his bond.
Judge, he has a $6,000 bond on 2 third-degree felonies. He's homeless. He's 64 years old. He does have a mailing address where he could get court notices. That would be of his mother, who resides in Fort Lauderdale. She's not going to be able to post his bond. Judge, my understanding, he was incarcerated. He served prison time, I believe, got out in 2017. But from what he
Sir, are you
advised me,
okay? Are you all right, sir?
The medication, ma'am, they're giving me.
Do you want to
Yeah,
sit
hold on
down?
to this.
You could sit in the front row if you need to sit, if you're concerned. I'll talk to you from there.
I want to hear.
Right here, sir.
Yeah, we'll get you a seat. Don't worry. I don't want you falling over.
I've done that a couple of times.
Well, I don't want that to happen here, okay?
Yes, ma'am.
All
He
right.
did tell me he has health issues, Judge, but we're asking for pretrial release on his behalf.
Your Honor, the reason, the reason that Judge DeLuca set a $5,000 bond on the burglary is because of his criminal history. Broward County alone, 2014, possession of cocaine, PVP, little over 40-month state prison. 2014, burglary of a conveyance, same sentence, but that was as a habitual offender. 2014, burglary structure, same sentence as a habitual offender. Possession of cocaine, 2014, same sentence. 09, burglary of a structure with a battery and grand theft, 2-year state prison as a habitual offender. He has something, Madam Pretrial, what did you say? Something like, was it 70 or something? Yeah. 45 prior arrests. And,
Okay.
Quite a few of them were theft.
Okay. All right. Sir, I know you have some health issues and you're dealing with some stuff, but I'm just going to leave the bond as it is, okay? Given the prior record and my concern for the community. So I'm going to just leave your bond as the total. I guess it's a total amount of $6,000. Is that what it was?
Correct.
Okay. I'm just going to leave it as is. All right. I don't have anything else. Yay. Very long day. All right. Now I get to go do my normal work. All right.
It was a pleasure to see you, Judge.
Likewise.